Okay, here we go.
Okay, so Janine is going to help me manage the chat. So you're welcome to put questions in the chat. You're also welcome to just come off mute and interrupt me. I think questions are best when they are asked in the context of the presentation, right? So we'll have time for Q&A at the end, but if you have a question that's relevant to the slides that we're discussing right now, I welcome the interruption and I would be happy to talk with you about it. So welcome to Understanding Contract Basics, business contracts here. My name is Lindy Laurence. I'm with Rational Unicorn Legal Services. I'm a lawyer, so I'm going to give you this disclaimer right off the bat. We are giving you this information as general information. This is just information to help you be better at your business. This is not intended to be legal advice. Legal advice would be like if I said, Rob, in this situation, you should do that. General, generic sort of hypothetical information is given as legal information. And we're going to go over a lot of things in a short amount of time. It won't be too fast. I will moderate my speaking and we won't race through this. But the idea is that don't write everything down. If there's things you have questions about or things that sort of plant in your mind, reach out. I'm happy to talk with you about it. We have other attorneys at the firm who can help you, or reach out to your legal counsel that you already have a relationship with. Anyone can help you with this. Um, about me. So I'm Lindy Laurence. I'm an attorney and the owner of Rational Unicorn Legal Services. I'm a second career attorney. When I was 40, I decided that it's never too late to change your life. I was a single mom. I had two kids. I went back to law school and I loved it so much that I went back and got a second law degree. Rob, now you're really going to think I'm quirky. I got another law degree in tax because I also love tax. So the thing to keep in mind is that as a business owner, we can do all kinds of things that affect our business, but sort of the hidden layer in that is what is the tax impact of this decision, or can I make a better business decision that has a different tax impact? And so that's the experience and the credentials that I bring to this work, along with 25 years actually working in industry with this. So I used to be a small business owner. My career started off working at a startup here in Seattle, Cranium. Maybe you guys remember that fun little board game company back in the late 90s. Um, uh, my favorite food is tacos. I have a brand new 1-year-old puppy that you may get to see because he likes to come over and poke his head up in the camera. And one of my favorite things to talk about is contracts. My second favorite thing to talk about is taxes, but we're gonna hold it to contracts today. So about us. This is a little bit about Rational Unicorn. For those of you who are not aware, we are a small firm that was founded in Portland in 2017. We have now expanded and we serve the whole West Coast. So we have attorneys in Washington, Oregon, and California. And we think we're a little bit different. There's not a lot of law firms that name themselves after a magical, mythical creature. And we hope it signals to you that we just approach the practice of law from a fresh and different perspective. And those of you who've worked with us know we try to live up to that promise. What is a contract? How funny you should ask. A contract is simply a legally binding agreement between two or more parties. It outlines the expectations, responsibilities, it protects everyone involved, and it has 6 key elements. So you need these things to make sure that you have a binding contract. My first experience with contracts was when I was 11. I really, really wanted a 18-speed mountain bike, and I didn't have the money for it. And so my dad was like, okay, I will pay for this mountain bike and you can pay me back. And he actually drew up, I, I remember it very clearly on that 3-ring hole punch school paper, right? Where he drew up the contract and he taught me okay, here's the things, it's a $300 bike, and this is I'm not charging you interest, and this is how we're going to pay for it. And oh my God, my family had a wood stove. I hauled so much firewood that winter. I think my parents paid me a nickel a log. I paid that bike off very slowly, but very, eventually I got it paid off. And that was my first experience with okay, a contract. Here we have it written down. We understand what everyone is looking at. We are literally on the same page with this. And we've got offer. I'm offering to do this to you. Like my dad said, I will buy the bike for you. Acceptance, okay, I will let you do that. The consideration was it's going to be $300 and you are going to pay me back. The legality has to do you can't form a contract where the topic of the contract itself is illegal. If you wanted to hire somebody like a murder hit for hire, right? You can't do that. You can't be like, yeah, but I have a contract. Well, you can't enforce a contract if for something illegal. The two other things are capacity and consent. So there's a couple different groups of folks that we just assume do not have the legal capacity to make a contract. Those are generally children, right? You can't get a 5-year-old to sign a contract. We both know that 5-year-olds change their minds all the time. We don't want them signing a contract, but also minors up to a certain age, 16 or 18, the contract can easily be voided. So just be careful when you're working with minors or folks without legal capacity. Also be aware that sometimes very old people, the elderly who may have dementia or other incapacitation issues may not be able to sign contracts. Or if you have adults that require a lot of care or maybe have learning disabilities and don't have the ability to fully comprehend what they are signing, those might not also be enforceable. And you have to have consent. You can't hold like a gun to somebody's head and say, sign the contract. And then like, well, you signed it. Or you can't coerce them into it. Like, unless you sign this contract, I'm going to kidnap your kids, right? So contracts are essential. You can't just make a contract willy-nilly. It's not like a couple of friends sitting next to each other at the bar saying, hey, I'd sure love to have, buy your farm whenever you sell it. And you're like, really? How much would you pay for it? And they're like, oh, I'd give you $500,000. And you're like, boom, sold. That's not a contract. We need more details than that. Right. What we have there is an offer, right? It's just the first part of it. So a contract should also be written down. Why? Because we are trying to ensure the clearest relationship, the clearest engagement as possible. And if you don't write it down, it's generally not enforceable. All 50 states have a rule called the statute of frauds. And what that means is if there is a contract that is A, over $500, or takes more than a year to perform, or has to do with real property, it has to be in writing. So it doesn't matter if you and somebody else have decided that they're going to buy your car from you and it's $15,000. That contract must be in writing to be enforceable. So keep that in mind. If it's not in writing, it doesn't exist. It's just kind of like it evaporates. Why should we use them? Well, literally to protect from misunderstandings. They outline the agreement, the meeting of the minds at the time. And it's not just words that we share with each other. It's words that are written down on a page that we can objectively understand what those words mean. We can take it to another person and ask a lawyer, what do these words mean? We can take it to a financial person and say, what do these words mean? We can take it to a manufacturer and say, interpret these specs, right? It's things that we can transfer knowledge and information between us, and it's affixed. It is in stone. It's not transitory like email. It's in a document that we both agree to. It acts as a legal safeguard so that if somebody doesn't fulfill their promise, then we have a document that can be legally enforced. We had a business fundamentals presentation last week. Some of you may have been there, so you may hear a little bit of repetition, but I want to remind you that, what was I going to say on this? Legal safeguard. Contract provides a legal document that can be enforced. Oh, so nope, I lost my train of thought. We're going to come back to it. It also provides you with a professional image. So using contracts with your clients indicates I take myself seriously. I know what's going on. I'm serious about this. It really builds trust and professionalism. So contracts are the things that underpin every business relationship that you can imagine. Um, I went to UW Law. I go up there every fall to talk to the new incoming class and like get them really excited about being a lawyer. And I tell them, look around. Every single thing that you can see is held together with a contract. Buildings are built because contracts are signed. Employees are hired because contracts are signed. People have business relationships because they have contracts that sign. It's like the hidden fabric that really holds our businesses together. So if I remember what I was going to say, back to legal safeguard. So this is what's kind of so magical about contracts and one of the reasons why I like them so much. Just like we have statutory law that our legislature passes, right? Things like speeding laws or our criminal code or our building codes, those are law, those are enforceable. You can take them to any court in the state and the judge will enforce them. A contract becomes private law, which is just as enforceable as public law. And so you can take your contract anywhere to any court and you can say, hey, this is the obligation of so and so. They didn't do it. I need you to help me enforce this. And the courts will actually enforce your contract as if it has the same weight and the same enforceability as our public laws. And so, in that way, contracts are very powerful, and they put a lot of power into the hands of people, and it really helps the law to work for people in exactly the ways that you tell the law you want it to work for you. You can put almost anything in your contract, and so long as it's not illegal and it's not against public policy, the court will enforce it. Now, do contracts have to be fair? Absolutely not. Most contracts are not. Many contracts are not. Why? It's because people come to the table with different bargaining power, right? Like if I went to Costco and I wanted to um, how about this? We all have a cell phone. When you get your cell phone, we all sign that cell phone contract user agreement. Do you have any bargaining power when it comes to Verizon? No, none at all. You cannot say, hey, Verizon, I want to change this contract clause. I don't like that. I feel like it's not fair to me. They're going to say, okay, go somewhere else. We're not changing our contract just for you, Lindy. So it has to do with bargaining power, but an unfair contract is just as enforceable as a fair contract. Why? Because that's life under capitalism. The courts understand that there could be lots of reasons why you may agree to a deal that doesn't seem fair. Maybe you really want to sell your business and this is the only buyer you have, and that's the price they're willing to pay. Maybe you really need to develop this relationship with a vendor because they're the one who has the technology that your business needs, right? So there's lots of reasons why there may be unequal bargaining power between the parties, but it's super important to realize what goes into the contract is enforceable. I have helped a lot of clients with terrible contracts, and they're like, but it's not fair. It doesn't matter. It's what you agreed to, and it's how the court treats us as adults. The court doesn't treat us as children, so to speak. They see that they are capable adults. They went into this with their eyes wide open. They had the ability to read all of the words on the page. They're indicating their understanding and agreement to them. And now we hold everyone accountable to the words on the page. What if you say, oh man, we forgot to put some stuff in there? We need to go back and do this. Well, now you're going to have to amend your contract. And that's a whole process. You don't get to just start shoving terms into the contract if you left them out before. So contracts function to draw some lines around the relationship. Anything on the four corners of this page is enforceable, but anything outside of it is merely noise. And it's like, okay, that may help us understand the context of the contract, but those terms do not get shoved into the contract and enforced. Only what is written down can be enforced and nothing else. So there are as many types of business contracts as you can think of business relationships, and there's no one size fits all. So here is a partial list of just like a few examples of what different types of contracts. So we've got services agreements, sales agreements, lease agreements, either for property like a car, some furniture, electronics. Maybe you're renting your servers. Maybe you're renting your commercial space. We've got operating agreements and shareholder agreements, non-disclosure agreements or confidentiality agreements, loan agreements, fiscal sponsor agreements, employment agreements. Like the variety of contracts is so vast, and there are principles that underpin them all, but the facts and circumstances of each relationship need to be pulled into that contract to actually reflect the relationship. Understanding the variety of business contracts really helps to tailor them to specific needs. For example, if you have a simple, a very straightforward business model where, like, I meet with clients and I meet with them for an hour once a month because I provide maybe professional coaching services. There's not a lot of risk in that contract. The risk is maybe the client won't show up and you'll have wasted an hour. Maybe the client won't pay you and you will have to chase them for payment. Maybe you'll have a disagreement about what type of services to perform under that, but those services should be spelled out in your agreement. We're not worried really about like catastrophic risks, like what if somebody was working in a like in a volunteer thing and they have a chainsaw and they harm themselves? Like, no, we're meeting over Zoom. Nobody's going to hurt themselves. Nobody's going to slip and fall in this situation. So if you have a very straightforward relationship or a very straightforward business model without a lot of risk, your contract can match that business relationship. It doesn't have to be over-engineered. One of the things that we see so much is that clients will have these really, really robust contracts where like it may be 15 or 20 pages and you just go, well, why do you think you need all this? Help me understand what could go wrong in this relationship. Let's appropriately protect against that risk. Let's not pretend that the whole world is out to get you and there are monsters behind every closet door. Let's actually identify the risk of this relationship and let's keep our contracts simple, plain language, and straight to the point. I was reading a Harvard business document a couple days ago, a study maybe a couple weeks ago, where it talked about people feel like legal language is somehow more enforceable, right? Like if we say, I, Lindy, am going to give this to Jennifer, um, like I should say some, I, Lindy, party number one, do hereby give this thing to Jennifer, party number two. Putting it in quote unquote legalese doesn't make it more enforceable. It makes it more confusing. And so unless you're trying to really impress someone, and I think maybe that's even the wrong approach. I would not suggest trying to impress people with like really super wordy or overly engineered contracts unless you're really trying to uh, um, protect against a very specific risk. I recommend that we keep contracts short, to the point, and make it easy for you and your clients to go through them and review them together. Contracts actually can be a way of facilitating and promoting your business. Like imagine sitting down with a client and saying, "Hey, I'd love to onboard you. Let's take a minute and go through my services agreement so you can understand how we like to do business here." And you sit them down and you show them a neat contract and like a friendly font that has words they can understand, and it's 3 or 4 pages. It's easy for you to get through, and you talk about client expectations and my commitments to you, and here's what I will provide to you, and here's my billing terms. And it actually facilitates and strengthens you. It facilitates your business. It strengthens you as a business leader and a business owner, because now you really look like a pro. You've got a great contract. You know what it means. You're able to easily explain it to your clients or whoever you're working with, and you're able then to either use it or negotiate with it or otherwise use it to promote your business. Best practices with contracts are be clear and concise. Think about the types of things that folks are going to argue about. Did you pay me? Did you give me the thing you promised? Was it on the right timeline? Those are the major things that folks are going to disagree about. So make sure that it's very clear. The who, what, when, where, why, and how, right? Just use that. Outline the duties and the obligations of each party. Include termination provisions, because if you need to uncouple or get yourself out of that relationship, we need a smooth and peaceful path for you to do that. And we always recommend addressing confidentiality as well as ownership of intellectual property if there's going to be any that's generated in the relationship. Negotiating contracts, you'll probably are very good at negotiating contracts. And this is certainly not meant to be a masterclass in negotiation. There are some great books out there like Getting to Yes. Getting to Yes is a great book about just like business in general and facilitating consensus and collaboration. But when you're negotiating contracts, the number one thing that I advise my clients is try to understand the other party's perspective. Try to understand what's really important to them so that you can not only meet their need, but as you're doing so, you can sort of present, okay, this is what you need in your contract, and here's also what I need for it to say. And you can find harmony between those things. Obviously, mutually beneficial outcomes are going to be the goal of any contract, but sometimes contracts are just meant to prevent you from a bad situation getting worse, like a settlement agreement or an employee separation agreement, where you just need to say, no, we're separating, and we're just like uncoupling, we're separating and walking away. And don't be afraid to consult with legal counsel, and don't be afraid to let the process take the time that it takes. In my experience, business deals ripen the longer that the conversation carries on. The parties get to know each other better, they understand the context better, and they're able to reach better outcomes without trying to rush through it. One of the other things that we also like to promote when we're talking about contracts is using a term sheet, especially if you're talking about a complex business deal, right? You wouldn't want to use a term sheet when you're talking about like a client services agreement or one of your sort of routine contracts that you use, like an NDA or something like that. But if you're going through a business acquisition or you're talking about some sort of joint venture or joint development with someone, a term sheet can be really, really efficient for making sure that we get, again, on the same page before we go to a bunch of work to draft legal documents. As a lawyer, it's always nice to know what are the terms that I'm going to be drafting because then I can make sure the language says the right thing. But if I'm drafting a contract with a lot of holes in it, like, oh, we still need to negotiate that point, we still need to negotiate that point, it makes it very difficult. And it actually creates a lot of inefficiency because you don't even know, are they going to accept that point? Should I even spend time writing the words around it? So a term sheet is really beneficial. It will help you identify deal breakers. It'll save you time and money, right? If these negotiations are futile or this really is a dead end deal, you can just move on. You can focus negotiations by resolving the important principal terms early on, getting you right to like, okay, these are the important points. We can figure out all those other ticky-tacky things later, but these are the really critical ones. It also fosters deal stability and commitment because even if it's not a binding term sheet, there's this sort of moral obligation to honor those terms, right? Okay, like I said that, I don't want to renege on my word. We want to be people who are impeccable with our words. So it can help foster deal stability and it also helps clarify the basic structure. So, you know, okay, if it's maybe maybe the contract's only one part of the entire relationship. It's probably the foundation of it. It's going to help spell out all of those terms and help you understand the deal. I like term sheets. They can be very straightforward to put together, and they can really promote a lot of great conversation. My guess is, like Rob, y'all have looked at contracts and you've probably reviewed a few in your lifetime. And so here's just some tips for like, I'm reviewing a contract. What should I be looking for? First of all, read it thoroughly. Take your time to read every part of the contract. Don't skim over it. Don't resist the urge. I know it's so hard. Your eyes are going to glaze over all the here tos and wherefores and herebys. It's going to be clogged with things like the buyer and the seller or the lessor and the lessee. And you're like, okay, who's who again? So I get it. It is hard. I'm asking you to do the hard thing and read your contracts because even if you have an attorney read the contracts, I can tell you the legal things. I can try to understand your business deal and make sure the terms are reflected accurately, but I won't know things like the other party's area of expertise or what your contribution is to it. And so I need your perspective on the contract to help me understand, does this represent your perspective of the business deal? We can work on all of the legal provisions together, but the substantive provisions about your business relationship, we really need your input on. So this isn't the sort of thing, it would be so nice if you could just delegate it to an attorney and be like, here, read this, tell me what I should know. But we actually do need your involvement to help us understand, like, okay, what is the actual deal? And then we can help you understand if it's represented. Look for ambiguities. Identify vague or unclear terms. Things like, we will supply up to 2 dozen of them. Well, up to 2 dozen, that means you could do anything between 1 and 24. And what if I need exactly 24 pieces of those things? So be aware of vague terms or even things like this to be agreed on mutually by the parties. Well, what if you can't agree? So now in the basic performance of services, you still have this, you've inserted a place of like further negotiation after you've already agreed to your contract. Um, Verify the parties and terms. You would be surprised how often people get this wrong, or it's like, wait a minute, I'm the lessor. I'm not the lessee. I'm the person leasing the building out, not the person renting it, or making sure that you're appropriately named. If you have a business that you're operating through a legal entity, your legal entity should be represented on there. If your business is intending to be bound or is a party to the contract, if it's a contract between private individuals, make sure their names are on there. Um, a lot of that information is in the preamble where it'll be like, this agreement dated effective to be September 17th, 2024 is by and between Lindy Laurence and Jennifer Gill and the parties, blah, blah, blah. Lindy Laurence, an attorney in Washington at this address, and Jennifer Gill, a provider in this, in Portland, and it identifies the parties. Why do we want to actually identify the parties with some sort of specificity? Because there may be a dozen Lindy Lawrences in the world. And if we need to enforce this, we need to know exactly which Lindy, the one that lives in Washington, the one that's an attorney. There may be more than one Jennifer Gill that lives in the world. And we need to know which Jennifer Gill. If we need to enforce this, who do we reach out to and talk to? So parties are actually a really critical term. Check for compliance, make sure that the contract complies with relevant laws and regulations. This is really important, especially as the law is rapidly changing on a number of different points. For example, non-compete agreements. Most of the time, non-compete agreements are void between employers and their employees, and sometimes they can be void between a business and its independent contractors. It depends on the facts and circumstances. So this is one of those things where you get the very unsatisfying legal answer of it depends, right? It depends on whether something is enforceable depending on the facts and circumstances. And that really leads us to this last point is seek legal advice. Lawyers are going to know a lot of things, and we will have seen a lot of things that you just won't have exposure to in your business. And so talking to us, we can help you with it. For example, we often have a lot of clients who bring us a commercial lease. Commercial leases are substantial. They're between 40 and 70 pages, right? It's got all kinds of information about repairs and obligations and personal guarantees. And it's a lot of work to review a commercial lease. And a lot of time clients don't want to do it. They're like, no, I'm sure it's fine. All commercial leases are the same. It's probably fine. But that's actually a huge red flag for clients. Commercial leases are one of the places you can get in the most trouble ever. We're all very familiar with the residential renter protections, but commercial tenants have no such protections. And there are no statutory rules about what landlords can and can't do. I just saw a commercial lease agreement yesterday where the term was the landlord wanted to be able to relocate the tenant to any space at their discretion. Like, can you imagine you're in an office, maybe you're in a restaurant, whatever your business does, and the landlord's like, knock, knock, knock. By the way, next month you're going to have to move to that suite down over there and up 3 floors. And you're like, wait a minute, I'm going to have to change all my addresses. I'm going to have to change, I'm going to have to move. It's going to be incredibly disruptive. You can't do that. And the landlord's like, guess what? I sure can. It's in your lease. That, you're agreeing to those things. And I'm not saying we can always negotiate those things away, but you should go into every contract with your eyes wide open, knowing all the different things that could come out of that relationship. So a lawyer can help you understand, okay, that, for example, all the intellectual property they're going to create for you, they're saying they still own it. And you're like, well, that's not supposed to be the point. I want to own my intellectual property. I'm hiring them to do it for me. So there's just a lot of things that we can help you understand, we can raise for your awareness, and we can help you understand what's the best way to negotiate this. Is this a sticking point on the deal? Is it a deal breaker, or is it something that we can navigate around? Common contract mistakes, well, it's kind of like the opposite of what we've talked about with best practices, right? Like common contract mistakes are vague language, terms that are open to interpretation. If you're using a term like net income, define your term. Income less rents, operations, cost of goods sold, and any other things deducted against it. Like maybe you have taxes deducted against your net income. You can but don't just use the word net income or the term net income without defining what it is. Or say, we can use the building located at this address consisting of X number of square feet, not just say, yeah, they get to use the building. Well, what part of the building? Where do people have the entitlement to be? What can we actually do to that space? Make sure that there's no missing terms. That seems like a no-brainer, but when you get into a contract and you're kind of really deep into it, you can be so close that you sort of lose sight of the overall big picture. So this is another great reason not to rush through them. I always recommend sleeping on it, right? Read a contract, put it away, go to bed, let your brain decompress, open it up again the next morning. You will have fresher thoughts. You will have more clarity when you read it, and it will make more sense to you. So don't be afraid to sleep on things. And then revisit the document, because once it's signed, you're committed to what's in the document. There's no oh, shoot, I made a mistake. You signed it. That's what you agreed to. Now that's what we're all obligated to. Avoid overly complex clauses. Why? Because nobody understands them. And you're going to have, if there's ever a dispute, you're going to have one lawyer on one side arguing for your client's perspective and your lawyer on your side arguing for your perspective. And with overly complex clauses, you, we're just inviting disagreement, right? If you have to really wade through it, like, okay, the lessor has to do this, and then it has to do this. And then if that doesn't happen within 30 days, then this is what happens. Draw it out, map it, put it in a chart, put it in a graph, whatever you have to do, simplify those things. Draw a process flow of how the funds are going to come in or how the process is going to work or the manufacturing cycle is going to be completed. Whatever it is, simplify things because sometimes words a picture is worth 1,000 words. And sometimes a well-formulated graphic can also be worth 1,000 words. This kills me when clients have a contract but have not signed it. And they're like, well, we had an operating agreement, but we never signed it. And you're like, oh my goodness, why not? Why would you not sign your operating agreement? You had an attorney draft it up, or you at least agreed on it together, and now it's sitting in a drawer without any signatures on it. That's not binding. We cannot enforce something that you have not agreed to. So while you may have an agreement in principle, there could be lots of arguments for why there wasn't a meeting of the minds, and that was never signed, which indicates it is not binding. Again, if it's not written down and documented and signed, we've got to sign it. It's just almost impossible to enforce. And then don't ignore updates. Please regularly review your contracts to ensure that they reflect any changes in either your business circumstances, perhaps your payment terms have changed, perhaps how you deliver services have changed, perhaps your other terms have changed. Regularly review them. The law also changes. We try to keep the law pretty static, but the law is dynamic. It changes just like people in society change, and it changes almost as rapidly as those two things. And so please, what I recommend is just once a year, you do a little corporate governance. Maybe it's the same time you do your business, you renew your business registration, or maybe it's at tax time. Just link it to whenever you're doing sort of corporate governance and fiscal housekeeping. Just set aside 2 hours to review your contract. Reflect on what are the issues that I've had in enforcing my contracts this last year? Where are the questions that clients always raise? What is the thing that I'm always having to provide additional feedback on or additional explanation? And then let's fix it. If you're already working with an attorney on this, it's really easy for us to go in and change this or update that for like just really efficiently. Enforcing agreements. This is probably the best and worst part of contracts is that when things don't go well, a contract gives you a path to resolution, but it also means that you may have to deal with some difficult people or some difficult situations in order to enforce your agreements. But you should understand your rights. So always go back to your contract. Know what it says about what you're able to do because it's really embarrassing when you're like, hey, you're X amount of days late on that payment. And they're like, well, your contract says that I have 30 days after the invoice. Like you're going to send me an invoice at the end of the month in 30 days. And you're like, oh, shoot, I meant that I was supposed to get paid on day 30, not like 30 days after that. So understand your rights, know what your contract says, don't be an amateur. Um, Keep good records. Um, don't rely on you said this, you did that. If you have a conversation that you need to document, have the conversation, follow up with an email that says, hey, Jennifer, thanks so much for the conversation that we had earlier. I'm summarizing my understanding of our points below. Please let you know if you have a different perspective. Thanks so much, Lindy. Right? And then you've got, okay, we had the conversation. 10 minutes later, I sent this email when it was all still fresh, and you're creating a record there. You can also, like, if you have correspondence between someone and you're like, yeah, this is going to be an issue later, print out that email, save it in a folder so that you don't have to dig through your email records later. Your future self will thank you, or your attorney will thank you when you have all of the information in one spot that's easy to review and analyze. I love alternative dispute resolution. this might sound weird coming from a lawyer. I think the courthouse is one of the worst places business owners can be. You are spending enormous amounts of time, energy, and money to resolve a dispute through the courts. It's going to take up massive amounts of your attention, focus, energy, and brain space over the next year to 18 months to 2 years. And the outcome is so uncertain whenever you go to court. There's no guarantee that you'll expend all of that effort and have a positive outcome. And even if it's kind of a wash, if nobody really wins or loses, you still have thousands of dollars of legal fees that you're going to have to pay for. And that is not work that moves your business forward. There are lots of reasons to go to court, to protect your intellectual property, to protect a business deal, to enforce a contract, maybe with payment. But please balance the rewards if you win against everything else that you'll have to go through to get there, and weigh those to yourself. I am not a person who loves adversarial situations. I do not thrive on that. When people are like, oh, I told my kid they should be a lawyer because they're so good at arguing, my response is, lawyers aren't supposed to argue. We're supposed to be problem solvers. We are supposed to be people who facilitate the free flow of commerce and facilitate business relationships and ensure people are protected. We're not supposed to be up there arguing. But there are some folks who thrive in adversarial situations and get a lot of energy from that. I'm not. And most of my clients are not either. They're like, no, this is like, I just need to solve this and move on. If you're looking for a quick, peaceful resolution to things, I really recommend alternative dispute resolutions. Something like good faith negotiation. If that doesn't work, then we go to mediation. If mediation is unsuccessful, then we can go to arbitration. But let's keep people out of the courthouse unless the facts and circumstances or the risk is so astronomically high that it makes sense to engage in that legal process through the court systems. Um, I'm a big fan of alternative dispute resolution. If mediation fails, legal action is always an option, but honestly, unless we're talking about hundreds of thousands of dollars or even significant thousands of dollars, it's just not going to be something that pencils out. And sometimes as business owners, we just have to walk away from it because we don't want to spend thousands of dollars. Like, no, this is not moving my business forward. I need to focus on these things. I just need this to have a peaceful resolution so I can move on. We can help you with that. Let's see, how are we going? Okay, we're almost to the end. We're doing great. This is my last slide. Contracts, again, like they are a magical, they're not mythical like unicorns, but they're almost as magical as unicorns because they have the ability to create this mutual benefit. They set clear expectations. They help the parties mitigate risk. They strengthen relationships when parties feel secure and they understand their roles. It really helps strengthen that relationship. It promotes efficiency and productivity when everyone knows what we're supposed to be doing. It's like we can just have things hum along. We don't need to spend a lot of time talking about it. We can just do the thing rather than talk about the thing. They offer financial security, not only spelling out the payment mechanisms, making sure people understand and are clear about them, but it also allows you to enforce those payment mechanisms if folks neglect to pay. And um, that allows us as business owners to actually like plan things, right? I know if I have this client who's signed up for marketing services for all 12 months, I can begin to count on that revenue and I can structure my business around it so that I can provide the client with outstanding service and also run my business with the minimum amount of friction as possible. And they give good dispute resolutions. The best contract in my opinion, is the contract that stays in the drawer. It's the contract that everyone talks about. We sign it, we move forward in our relationship, and we never have to look at it again because you're clear on the terms, you're clear on the deliverables, you're clear on the outcome, and everyone is aligned. It's only when there are disputes that folks go back to the drawer, they dig out their contract, they start paging through it to see, like, I think that's wrong. Jennifer's actually supposed to give me this, and she gave me that instead. And now I need to figure out what are my remedies. It's when there are disputes that folks go back to their contracts. So a good contract at the outset is just really going to like get everyone on the same page, close the door on the negotiations and the questions about how are we going to do this, and allow you to move forward into just providing outstanding service to your clients and doing the thing. Let's see. Okay, this is time for questions. I'm not sure if anyone has any, so hang on. Let me just share this one more thing. We'll go back to questions. I just wanted to leave this up on the screen so that there's a QR code there if you want it. Every fall and spring, we do a Glow Up Your Biz speaker series, and I'm so excited about it this year. We have a slate of amazing folks talking about all kinds of great things, from finances, retirement planning for you and your small business, whether you have employees or not, tax preparation for micro entrepreneurs. We're going to be talking about legal updates, remote workforce, digital nomads, intellectual property, commercial leases, all kinds of great things. So go ahead and look at our Glow Up Your Biz. And if there's other things you want to try, please sign up for those. Okay, Q&A time. I'm going to pause it here. Let me go back to that. I'm going to pause it here. Does anyone have any questions or anything you want to talk about?
Nope, but I want to say this is great. Thank you.
Thanks, Rob. Okay, I'm dropping my name and my email into the chat, and you can also reach out to us at, I think most of you already know me and the business. But you can reach out to rationalunicorn.com if you're interested in meeting with any of our attorneys or talking about these things. We would be happy to talk about contract needs, look at your existing contracts to see if this is something that needs to be updated or amended. And if you have like contract disputes or anything like that where you're having trouble getting payment or enforcing terms, let us know. We can help you enforce those as well. Okay, I'm going to stop sharing so I can see
So
your faces.
one thing that I wanted to ask about is like you were giving these comments earlier about keeping the contract as simple as possible, which I can appreciate. But what I've found is that if I have a comprehensive contract that I can use regularly, sort of like a template, and then I just customize it for each project, that I find that better for
Mm-hmm,
myself because then I'm already familiar with 100% of the language in it. It's probably overkill for some projects, but it allows me to go in and say, oh, well, I don't really need to deal with intellectual property on this one, so I can delete that paragraph, right? Or whatever.
mm-hmm,
I found that really useful to do it that way for myself. I mean, all my contracts are like engineering contracts.
mm-hmm,
And then the other side to that, or the other piece to that, that sort of was, I thought was interesting about what you were saying is like the parts that people usually argue over is the scope. And so that is something I negotiate with clients and subcontractors before there's ever a contract.
mm-hmm.
So that
Absolutely.
way we sort of agree on all that stuff first, and then they see sort of standard language
Mm-hmm.
in the contract, and then they end up having like 5 comments instead of 37 because we've already worked out the scope or something like that.
Right. And you've already got them aligned on exactly what they're receiving. What's the benefit of this contract, that whole
Yeah, like
scope
how
of
much,
work.
what's their budget, what's the
Mhm.
schedule. It's all sort of in the scope of work piece, and then the rest of it is just standard contract language.
Yeah.
Yeah.
So Rob brings up a great point where he's talking about a standard contract that where it's really just you're customizing the names of the parties at the top and the bottom, where it's like, hey, this contract is between these people, and then we sign it at the bottom, and then fully customizing a scope of work that's then attached to that. And that's one of the approaches that we use a lot with our clients because it allows you to not fiddle with your contract, accidentally deleting things or renumbering paragraphs or breaking it, so to speak. And then you can put all of the highly customized details in a scope of work. And then, right, then you can have like 5 scope of works. And you're like, okay, this is that kind of scope of work. I'll customize it for this client. I've got another scope of work over here. So you kind of have your own library of tools that you begin to use. So you're not recreating the wheel every time. Contracts should promote your business, not slow you down. I don't want you
Right.
spending 3 hours on a client services agreement, right? Like, get to the part where you get paid, get to the part where you land the relationship and reach agreement. I totally agree with you. When I say I want contracts to be simple and straightforward, I don't mean that they're not comprehensive. I mean that they're not over engineered. We don't need to
Right.
have 3 pages of indemnification, right? We don't need to have like 2 paragraphs defining confidential information, right? We can
Yeah.
just have like simple statements of those things that are big enough to encompass the risks or the business deal, but are not just, oh, Microsoft sent me this one, and so I'm going to use Microsoft's agreement, right? It's like, no, that's probably going to be
Yeah.
way more robust than what you need. So thank you for bringing that up, Rob. That's an excellent point.
Yeah, and I've also found that, a lot of the work I might do is directly for, say, a municipality or some community, and they often have standard terms and conditions with the request for proposal. And so you often know what you're getting into before you even submit the proposal.
Hmm.
I also use a master services agreement with some of
Hmm.
my subs so that I can issue task orders for different projects. So
Smart.
that has saved me a
So
lot.
you've got your contracts that are the foundation of every relationship, and that is right there. And then you can just send them the work, and you know you're protected by confidentiality in those master service agreements, hopefully some non-circumvention, so your subs can't go around you and try to get right to your clients. You probably have some non-solicitation, so they also can't solicit your clients. Good. I'm glad.
Yeah,
Yeah. Excellent. Thank you, Rob.
sure.
Any other questions? Suzanne, there is no right or wrong answer here. Whatever you say in your contract, you can call it a statement of work, you can call it the services page, you can call it a scope of work, you can call it a list of deliverables. Whatever you decide to call it, just be consistent so that your contract says, Suzanne's going to provide the services described in attachment A, scope of work or scope of services, right? And then every time you say scope of services, we know it goes back to attachment A, which is outlined. So the terminology doesn't matter. It doesn't matter if you call it Big Bird's list of things to do. It will still be legally binding on you.
Lindy, if nobody else has a question, I'm hoping this could be beneficial to others as well. But I just, as you know, I just am a small business, recently was in an LLC partnership, had my operating agreement. I actually came to this to be like, how might I improve on this next time, or what could be in
Mhm.
that operating agreement to, because what ended up happening is we got into we went back to our agreement, and my business partner didn't really like the outcome of what was specifically laid out. And so then it became, we had to negotiate. And so I guess my question is, what I learned is that having an operating agreement was great, but there's still lots of room for interpretation. And ultimately we had to come to an agreement. And like you said, there's no way we could afford to go to get legal support. And so I was
Right.
like, I want to work this out. With that step of mediation, what does that look like? And is that, because we ended up just trying to not to just figure it out ourselves. I'm still, who knows? Anyway, moving on. But
Yeah.
what does mediation look like? And how does one really get someone to, do each party have their own representative, and is it expensive, or what is that step before you actually get to the legal?
So mediation generally does not have legal representation. It's
Okay.
a mediator who may have a legal background, but
Okay.
um, often, often does not. Maybe they'll have a background in dispute resolution or conflict resolution or communications. Um, there are a number of mediators who can help with this, and there nowadays it's very rare to see it be in person. Generally they're remote over
I
Zoom or
see.
something like that, and it's just a way of having an independent third party help you, like, okay, these are the things we agree on, we don't need to keep going around on that, these are really the places where we are still a ways apart and we need to reach consensus, and they will help to. Elizabeth, do you want to
I
answer this question?
know.
You're a mediator, can you join?
Yeah.
Yeah, please.
Thanks.
I know
I'm
you
just,
asked, and I was like, "Tee, that's me." Lindy's got it, and Lindy, I appreciate you saying that. And a lot of attorneys also agree that mediation is much better in some
So
cases. But
much
I'm
better.
also so grateful for court when we need you guys, because I don't want to take all the cases either. Jennifer, you're really just talking directly to the person. I describe it as having a supported, challenging conversation. And we mediate 2 hours at a time because no one gets better after 2 hours mediating.
True.
So we do
yeah.
2 hours, as many sessions as you need. And then people have a choice. They can have a written agreement. They can skip that. They can do it verbally. They can not agree at all. You can choose to file that with the courts. You can choose not to. But it's a confidential space we do co-mediation. I think that's best practice in my opinion. And
when you say that each person has a mediator representative, is that what you mean by
it's like we're neutral, so we're on both
Both
sides, right? It's just there's two of us because there's two of you talking, and it's easier to keep track of if there's two people than if there's one. But generally it's kind of up to you, and we just say it's a way for you to meet your needs on your own terms instead of having a judge decide for you. And then you can always go to court. Like if it doesn't work out, you can always go. And sometimes you go to court, especially in family court, and the judge will tell you you need to mediate. Like, I don't even want to hear this until you mediate. Just because it really should be, if it's a partnership and a business, that really should be the decision between the two of you. And if there are things you can't agree on, go to the judge. But if there are things you can figure out a mediation, you have more flexibility in mediation, because we're not binded to the precedents of law. Right? Like if you decide you are like, fine, if she takes you on a boating trip and you'll call it a day, that's fine with me. But a judge is going to be like, how much is that boating trip cost? That is not in precedent. You can't trade a boating trip for a business. You know, like they're going to have stipulations that won't apply in mediation because you have more freedom there. But I think I'll hand it back to Lindy. I hope that answered your question.
Yeah, thanks for chiming in, Elizabeth. Appreciate it.
Yeah, Elizabeth, thank you so much. That's really helpful. And Jennifer, there's private mediators. There's also like dispute resolution centers. There's the Oregon Mediation Center. There's tons of resources because again, court is expensive, it's crowded, it's lengthy. We want to keep people like, let's just solve problems rather than send people to court. And you had a really challenging situation because your operating agreement didn't accurately anticipate a partner withdrawing from the business. And because of that, it put in terms in there where you're like, that doesn't even make sense. Right.
Yeah.
And so I can totally understand why there wouldn't be agreement there, and why your business partner was like, nah, I don't like the way this is written.
Right. And I understood that. Then it was like, okay, well, now what do we do? So
what do we do?
Agreement, but yeah.
Exactly.
So thank you. I appreciate it.
You're welcome.
Hopefully that was helpful for others as well. So
it was really helpful for me. I appreciate it. And thanks, Elizabeth. I'm so glad you're here today. Okay. Any other questions? No? All right. I just want to say thanks so much to ORPIB for hosting this. I love community education. I think it's one of the ways that our community is strengthened. Even though it's remote, we're still forging those social bonds that are so important for us in this loneliness epidemic. We get to see folks who are like, hey, they're dealing with the same things I am. I'm not alone in this. So thank you, ORPIB, for making this space for us and for hosting us. We appreciate you.
Thank you so much for being here, Lindy, and everyone else who joined us today. Yeah, keep in touch. We love seeing you. When's your next Tuesday is Employment Basics, right, Lindy?
Next Tuesday is Employment Basics. So another scintillating topic.
I can't wait. Listening to you talk, I think
Janine,
maybe I should
you're
be
just
aware.
so positive.
I'm really into this, Lindy. Thank you so much.
Yeah, you're welcome. It's my pleasure. I hope you all have a great week. I'll see you next Tuesday. Take good care, everyone.
Thanks.
Bye-bye.
thank you.
Bye.
Bye.